Again, thank you everyone for being here. I have the pleasure of presenting Andrew Black. He's going to be our facilitator for today. He's a firm member out of the Pompano Beach office, although he does make it all the way down south to our areas. He's a board certified specialist in condominium and planned development law, and has been exclusively representing community associations since being admitted to the Florida bar in 2006. Mr. Black assists the firm's association clients in all aspects of operations, such as interpretations of amendments and governing documents, covenants, rules enforcement, contract drafting and negotiation. My favorite, the fair housing issues, conducting membership and board meetings, construction defect matters, compliance with federal and state statutes, and administrative requirements. Mr. Black has been a frequent lecturer on several topics of interest to boards of directors, managers, and owners, and has led various seminars providing consulting and education for property managers and certification for board members. And more important than all that, he's a joy to listen to, and knows how to keep this interesting for all of us. So Andrew, it's all yours. Enjoy.
All right. Thank you so much. It's always funny to hear what I actually do all day when it's read out loud like that. But first of all, I want to obviously thank Trident for hosting. I applaud every single one of you that is out there today for taking the time, hopefully learning something new, or perhaps reinforcing something that you already knew. Board members can be certified in one of two ways. The one way is I just call the Scout's Honor. You can just sign a very simple, two-line statement that you read your association governing documents, you agree to uphold them, and that complies with the statute. The second way is to take a state-approved education course, which is exactly what you're in right now. So you all are the more type A, proactive type. So I love to see that. Jeff and Jason did a good job going over some of the housekeeping items. I just want to touch base just on one or two things before we jump in. First is the surveys. I personally read every single one of them. So I really appreciate whatever feedback you all do give, whatever constructive comments you have. You love something or you want to hear more about something. So please do take the time to fill that out. Certainly for those managers out there, you obviously want to fill that out to make sure you get your credit. And just to follow up on something that Jeff said as well, and I usually forget to say this until about halfway through, but obviously today is a general education course, right? It's like Condo 101. It's not to be construed as direct legal advice for your board. So it wouldn't be appropriate if you're on your board to go back later this evening to your other members of your board and say, I met with an attorney, we got an opinion, we can do X, Y, or Z. Hopefully that may sound like common sense to a lot of you, but I've been presented with various fact patterns where I've had board members, even of existing clients, repeat back what they heard at one of these courses as actual direct legal advice. So I just wanted to point that out. The state of Florida requires us to go over 5 topics today. The outline that you have has 7 of them. So I'm going to do my very best to get to all 7. I usually do. We'll certainly get to at least 5. The first topic is the longest one. So bear with me a bit. You're stuck with me for the next 2 hours or so. The first one is operations, and that's obviously a pretty general term, and it covers a lot of matters that you, if you're on your board of your condominium now, will face, or if you're thinking about running for your board. And the main item I always jump off every course I do is to really highlight, stress, emphasize, underline, whatever word you want to use, is that every member of your board, you have what's called a fiduciary duty to the owners. A fiduciary is just a fancy word. It means you're put in a position of trust. So every decision that you make as a member of your board, the primary focus should be what is in the best interest of the entire community. Your primary goal should not be any personal agendas. Obviously, if your personal, want and your personal agenda matches what's in the best interest of your community, that's okay. But you really want to be viewing the prism that you look through every decision you make is you're in that fiduciary role. And courts historically, when they will review a breach of fiduciary duty claim, which sometimes owners bring, is courts will analyze what would an ordinarily prudent member of the board, what would he or she have done if presented with the same facts? And if you would have acted in the same way as an ordinarily prudent member of the board would have acted, you would have met what your fiduciary duty is. Now, of course, attorneys can argue over what an ordinarily prudent member of the board would have done, but courts give typically pretty wide latitude for board members to use what's called their business judgment. You might have heard the business judgment rule. And if you would have consulted with your licensed professionals, whether it's your licensed manager, we've got Trident here today, whether you would have consulted with your licensed attorney, your licensed insurance agent, your licensed engineer, all of those professionals that work in this field, if you would have done your due diligence, consulted with them, gathered your facts, and used your judgment and made the best decision that you think would benefit the entire community, almost always you will have met what your fiduciary duty is. You would have exercised business judgment. And I get asked a lot, and that's why I'm spending some time on this right off the bat. I guess I get asked a lot about, will I, as a member of the board, will I be personally liable for something I do, something I vote on, something that happens to my community while I'm on the board? And the good news is it is very rare for a board member to be personally liable. The bar is very high. The bar is you would have to have engaged in almost criminal activity. It would have to be willful, wanton, really reckless behavior, not just an ordinary screw up, which happens from time to time, right? The bar is very high. And certainly you all should have, if you're not 100% certain, obviously confirm with your insurance agent, but you should have what's called directors and officers liability insurance that protects against claims of just ordinary mismanagement and things like that. So almost always there won't be personal liability for a member of the board, and you always want to adhere to and comply with your fiduciary duty. Also want to just define a couple of terms that I'll be using a lot today. Hopefully you all know that every condominium association in Florida is governed under Chapter 718 of the Florida statutes. That's the Condominium Act. There's also Chapter 617 of the Florida statutes. That's the Not-for-Profit Corporation Act. And every condominium association is organized with the state of Florida via its Division of Florida Corporations as a not-for-profit corporation act. So there are sometimes language in Chapter 617 that will apply. But for the most part, when I say something is a statutory item, I'm referring to Chapter 718 of the Florida statutes. Also, I'm going to be using the phrase document specific. What does that mean? Every condominium, as you know, has the governing documents that the original developer drafted, recorded in the county where your property is. Those are the governing documents. You have the Declaration of Condominium. That's the highest one. You have the Articles of Incorporation, the bylaws, and oftentimes there might be board-made rules and regulations. So it's the the declaration, articles, bylaws, rules. Those 4 items comprise the governing documents for your community. They are unique. Our job, Trident's job, would certainly be a lot easier if there was one set for every community. Of course, it doesn't work like that. Sometimes the phrase I use is that they're not artfully drafted, which just is my nice way of saying, what the heck are they trying to say, right? They could be drafted in 1964, right? So those documents, they're specific to your community. And oftentimes questions regarding operations or who's responsible for what are document specific. So you, if you're a member of your board, part of your job certainly is to be familiar with what those governing documents say. And if you have a question on what something means, while I'm sure your property manager may know the answer and they want to help, they will rightfully say that's a legal question. Get with your association's attorney, and you would need to consult with whoever your counsel is, perhaps to get a written guidance on that you can keep in your community's files in case a similar issue arises. Okay, so I just wanted to define statute, define document specific, and certainly highlight what that fiduciary duty is. So going forward with this operation sections, obviously you as a condominium association, you have all the powers that any other not-for-profit corporation can have. You can enter into contracts, you can file lawsuits, someone can sue you, you elect boards, the board members elect officers. You are a corporation. You're not for profit, but you still are a corporation. And one of the primary goals of the association in its operations is the management and maintenance of the common element property. And I try to simplify this for my clients as much as I can, and I'll try to do it here for you as well. The condominium property really only consists of 2 things: the individual units themselves, okay, the boundaries of the units, and everything outside the boundaries of the units is the common element property. Yes, there may be something called limited common element property if you have, for instance, an assigned parking space, assigned storage space, something like where you have the exclusive use rights to that portion of the common element property. That may be deemed in your governing documents limited common element property, but it's still common element property. So you want to think about your condominium building, whether it's a tower, a high rise, a low rise, you want to think of it as it's either the individual unit within the boundaries of that individual unit, or if it's outside, it's the common element property. And who's responsible to maintain what is a document specific thing. A good rule of thumb, and virtually all governing documents say something along the lines of that the association is obviously responsible to maintain the common element property, and the owners almost always are responsible to maintain the property inside the boundaries of their own units. But there's always those weird fact patterns. There might be a vertical pipe in an interior non-boundary wall. Does it serve more than one unit? Does it just serve your unit? There's a leak there. Who has to fix that? It's just general wear and tear. And I wish I could just give you a simple answer for every condominium in Florida. Unfortunately, those types of specific maintenance questions, the allocation of who's responsible, that is document specific. Yes, it's true. A lot of times, if the pipe only services that particular unit, it's the owner, but not always. Okay. So if you come up with that fact pattern, who's supposed to fix a pipe? Definitely you need to consult with your governing documents. But you want to be aware of what the association's maintenance obligations are, because that's a primary operational requirement. And I want to touch base on something that comes up a lot. And also, I should say, the outline that you all have is a great resource. You should read it. You should use it. My style is I'm not going to be reading line by line. I always get bored when people read line by line. So I'm going to go through each of these topics, but I'm certainly not going to follow in strict order. But one topic is a phrase you may have heard. It's called a material alteration to the common element property. And the fact pattern that gets brought up a lot is someone will call me, whether it's a manager, a member of the board, they'll say, Andrew, we're thinking about doing this capital improvement project. Do we have the authority as the board on our own, just via a board vote, or are we required to seek and obtain owner approval first? And the question is, which attorneys love sometimes, is it depends. The analysis is as follows. First, is it a material alteration? Okay, there is case law in Florida over the years that has defined the material alteration as a perceptible change in the way something looks or something, the way it's used, okay? The state of Florida, via the Division of Florida Condominiums, has even held in their published arbitration decisions that a change of exterior paint color is a material alteration, okay? So keep that in mind if you're thinking about doing some type of improvement project. So let's assume the project is a material alteration. Let's use an easy hypothetical. You have an old secondary clubhouse. It doesn't get much use at all. The board wants to knock it down and install new tennis courts there, okay? I think we all hopefully can agree that's a material alteration. So the analysis is what Chapter 718 of the Florida statute says. The statute says check your documents first. What does your governing document say? And you follow that, okay? You follow what your documents say. Your documents could say a wide variety of things. It could say to do a material alteration, you need a majority of all owners to vote yes. You need 2/3 of owners to vote yes. Your documents could say something like, you only need the approval of the owners if the cost of the alteration exceeds a certain dollar amount. So there could be a wide variety of options that your documents say, and you need to follow that. What the statute goes on to say is if your documents are silent, it doesn't speak to the material alteration process, you need to seek and obtain the approval of 75% of all owners to go forward with a material alteration project. So certainly if you're on your board and you're contemplating this type of alteration, this type of, sometimes boards call it a capital improvement, you want to make sure that if you do need an owner vote, that you get it first to avoid a possible owner challenge to the state of Florida. Now, an important exception to the material alteration analysis that I just talked about is where the project primarily is an item of necessary maintenance or repair. Something's broke, it has to be fixed, okay? The board, without an owner vote, always has the authority to undertake a necessary maintenance or repair project. And there's a famous case in Florida, I say famous for us condo attorneys, where there was a beachfront condo. The seawall was in bad shape, bad shape. It had to be fixed to ensure the condominium building was adequately protected. The documents required an owner vote and the board needed to levy a special assessment to do this repair project. The documents required an owner vote to go forward. The board, since it was a necessary maintenance project, did not get the owner vote. The owner sued. The judge came out, and the judge's holding, which hopefully makes sense, was that if it's necessary maintenance, irrespective, regardless of what the documents say, the board has the authority to do so in order to fix what's broken, essentially. And I think the rationale makes sense, because what if that board went out to get the owner vote, the owners voted it down, is the board just supposed to let the seawall crumble and expose the condominium property to harm? The judge said no, and certainly that's been the general rule of thumb going forward. Okay, so that's the necessary maintenance exception to the material alteration analysis. Okay, so just keep that in mind. A couple other operational issues is certainly the condominium form of ownership. If you really think about it, it's an interesting form of ownership because you're living with shared walls, right? You each own your individual unit, and then you as an owner also own your pro rata or proportionate share of the common element property. And when you're in a condominium, you do give up some individual property rights that you may have had if you just owned a single family home. For instance, and this is in Chapter 718 of the Florida statutes, the association has the irrevocable right of access to each unit. Okay. Now, the association can't go in for any reason at all. The statute certainly, if there's an emergency, a burst water, burst pipe, if there's a fire, obviously we all, hopefully know that the association can certainly enter your unit at that time, but it doesn't need to be that type of bona fide emergency. The statute allows the association, they have access rights, should be during reasonable hours to enter a unit when required if the association needs to perform its common element repair obligations or to protect damage to other units or the common elements. Perfect example, lots of condos, you're doing a major concrete restoration project. The balconies are being repaired, there's structural matters, and in order for the association's contractor to have sufficient access to parts of the condominium property that they're going to fix, they need access to your unit. And the statute certainly gives that type of express access rights. So certainly be aware of that. Of course, if it's not a bona fide emergency, you should try to give as much advance notice if you're on your board as you can. There is no statutory requirement for how much notice you need to give if you're just going into a unit under those types of facts. But certainly you want to try to give as much notice as you can. Another big operational item that I always like to speak about, and let me see, bear with me 1 second. I might share the outline just for a second. All right. If I have it, if I don't. All right, I won't waste too much time here. Let me see. Let me just share this for 1 second. This might be an older one, but nope. Okay. I want to talk about just insurance, and I think it's important because there's a lot of perhaps misconceptions out there about the insurance requirements of the association, the insurance requirements of the owners, and this is a statutory item. Remember when I was talking about just the general day-to-day maintenance obligations of the parties? That's document specific. The insurance requirements, that's statutory based. And what the statute says, it starts with a very big premise and then it works down. The statute says that the association is responsible to insure everything, okay? All of the condominium property, but then it says coverage expressly excludes, and it lists 5 or 6 items. Those excluded items, they're excluded from the association's insurance requirement. Those are the individual owner's insurance requirement, and it's things that make sense. It's personal property inside of your individual unit. It's the coverings of the floor, the wall, the ceilings, if you have carpet, tile, paint, okay? It's window treatments. all of those interior unit items, cabinets, those are all the insurance obligation of the unit owners. Everything outside of that, that's the insurance obligation of the association. When this comes into play is you need to do an analysis regarding who has to repair what following an insurable casualty event. And that's the key phrase. An insurable casualty event is a sudden, unforeseen thing, like a fire, a burst water heater, knock on wood somewhere, a hurricane, okay? Those types of sudden, unforeseen events. If that happens, there's a fire, or I'll use a fact pattern that our firm dealt with not too long ago. A tenant thought it was a good idea to use the fire sprinkler in the unit to hold his hangers. That's not a good idea. Sprinkler got cracked.
Oh.
Yeah, it's not right, Jeff. That wasn't you.
No, it wasn't me. Wasn't me.
Okay.
I'm back to you. Sorry. Just wanted to break it up a little bit.
Yeah, absolutely. So that's an insurable casualty event. Water went everywhere, inside the unit, down the common elements, downstairs unit, all of this stuff, or just even a normal, just a fire or a burst water heater. Who repairs what following that event? And the easiest way I can explain it is whoever insures it is the party that must fix it. So the roof, the association insures it. There's a hurricane. There's damage following that casualty event to the roof. The association is responsible to repair that, okay? There's a hurricane. There's damage to your cabinets, your owner's cabinets. The owner insures that, the owner repairs it. The exception, which I kind of jumped the gun a bit, is when the source of the casualty event is the negligence of a party. Negligence just means someone acted in an unreasonable way that was the direct and proximate cause for the damage. So in that tenant sprinkler fact pattern, that's a negligent act. I think most courts would agree. So in that case, the association and any other owners, they could seek recourse against that responsible party, okay? But if there's not unreasonable conduct occurring that was the source of the damage, if it's just a regular hurricane or fire, the best rule of thumb is whoever insures it is the party that has to fix it. A couple other topics. I told you the first one's the longest one, so we are almost there. Another big operational item is enforcing what the covenants are, okay? The word covenant is just a fancy word. It means promise, as most of you all know. And your declaration of condominium, those use restrictions in there, like, for instance, you won't have a commercial truck. You must pay your monthly assessments on time. All of those restrictions, those are promises you are making. And those are covenants, and it's called covenants that run with the land. What does that mean? It means your documents are recorded in the county against your unit, and they run with the land, meaning they bind you as the current owner. And as soon as you sell your unit and title is acquired by the new buyer, they run with the land, and that new owner is immediately bound to those covenants or promises as well, right? So I buy a condominium, I better know what promises I'm agreeing to, right? And if I don't want to make those promises, well, then perhaps that condominium might not be the best fit for you. So certainly, I don't want to see a show of hands of how many owners read their documents before they bought. But as you can imagine, you probably have seen, there's lots of times owners will allege that they were not aware that a certain covenant is there. And at the end of the day, that those covenants, that's as enforceable as any contract as you'll ever sign. And it can be enforced in various ways. So I just want to make sure that owners are aware of that. But part of the board's job is obviously to uniformly and timely enforce what those covenants say, what the rules are, right? Boards should not be engaging in arbitrary enforcement, because you'll have owners claim selective enforcement, right? You can't enforce the commercial truck restriction against John Doe and then allow Sally Jones to have the same commercial truck, right? It's got to be uniform. Also, the enforcement of those rules needs to be timely, right? A good rule of thumb that we often advise our clients is, you as a board, on behalf of the condominium association, you should be enforcing against a violation within 1 year of when you knew or should have known that a violation existed. That should have known is an interesting phrase, right? That does not require that all 5 members of your board, or all 7, or all 9, or all 3, that every single one has actual knowledge of every violation that exists. But if you as a board should have known, let's say you have a commercial truck restriction, you're a large community, owner has a truck there for over a year, the treasurer lives on the other side of the building, never walks to that side, that treasurer says, well, I didn't know it was there. Well, that's okay, that may be true, but at the end of the day, the association via the board should have known. It's reasonable that you should have known that type of infraction was there. So good rule of thumb is to enforce restrictions within 1 year. If you wait too long, owners could raise as an affirmative defense to legal action something called a waiver defense. Waiver is essentially an allegation by an owner that the association sat on its hands for so long that they have now lost or waived its ability to now enforce against them. And I should note, if you're a new board, it doesn't matter that the old board wasn't doing things right? Waiver applies to the association. So if you're a new board and you're taking this course right now and you're thinking, I kind of like what this guy's saying, we should really be enforcing these commercial truck rules. And you do a little audit of your lot and you see 10 commercial trucks that have been there for years. And you say, we're going to send a violation out. You send a violation out. These 10 owners, or some of the 10 owners, come back and say, you've waived your right. I've had this vehicle since 2013. You can't now seek enforcement against me. And unfortunately, that owner may not be wrong. They might have a valid waiver defense. So if you're aware of that and you're thinking, all right, we know those 10 we can't do anything about, but the next truck that comes in here, truck number 11, we're going to nail them. And you send a violation notice out to that 11th truck. That 11th owner could conceivably say, well, how can you enforce against me? Look at these other 10. You can't selectively enforce against me. And that 11th owner may not be wrong either, right? So now you may be thinking, well, we're darned if we do, we're darned if we don't. What do we do? And there is a process in Florida law. It's not a perfect process, but it will at least stem the tide of more trucks. It's called the republication process. It sounds fancy and complicated. It's not. It's simply a board vote. The board has a meeting, notice is posted 48 hours. There's an agenda item, and it could simply say republication of Article XYZ regarding the prohibition on commercial trucks, just using this fact pattern. The board approves to republish, to basically reinstate this rule. And then you send notice out to all owners that for whatever reason, this article wasn't uniformly or timely enforced, but from a certain date forward, it will be enforced. Now, the caveat obviously is those 11 trucks that are in the community on the date that that republication notice is sent, those 11 are grandfathered in. You might have heard that phrase. That's what that means. Now, in the republication notice that you send out, you could certainly require those 11 trucks or whoever has a truck already there, you can certainly require them to register that truck with the association. So the association is aware of your truck. But if they do timely register those trucks, those 11 will be grandfathered in. However, if a 12th truck comes in after that republication notice is sent, you can enforce without worrying about those 11. And if that 12th owner says, well, what about these 11? You can't selectively enforce against me. The board can say, we understand. However, prior to you bringing that truck, the board went through the republication process. And there's case law in Florida establishing that it's a new day, essentially, from that date forward. And we get asked a lot, is it the owner that gets grandfathered in or the specific truck? It's only that specific truck, okay? The owner doesn't get to have as many trucks as he or she wants, right? It's just that specific infraction. You can do republication for animal restrictions, all sorts of things. So I always like to point that out. A couple other brief items on operations. Certainly the collection of assessments is a key operational requirement of the association. Whether your community pays your assessments, some people call them the monthly dues, whatever word you want to use, the statute says assessments, whether you pay them monthly or quarterly, those are obviously the lifeblood of how your community operates. That's how your expenses are paid. And unfortunately, if one owner doesn't pay, who makes up for the balance of that? The other owners, obviously, right? So it's important, if your community is experiencing a delinquent problem with lots of owners not paying on time, it might be a good idea to consult with your property manager, get with your attorney to perhaps adopt a new collection policy. Of course, there's always hardships. People go through extenuating things. Obviously, that can be taken into account from time to time. But I do think it's important to have a clear collection policy established. And the reason why I say that is the way the Florida statutes read is before your attorney can even file what's called a claim of lien against the unit, because the association has powerful collection rights. They can lien and foreclose, and actually an owner in theory could lose title to his or her home if they eventually don't pay. Obviously, that's the last resort, but the law allows that. But before your attorney can even file a claim of lien in the public records against that unit, there needs to be a statutorily, it's in 718, a 45-day notice sent to that owner via certified mail saying, dear John Doe, you haven't paid. If you don't pay within 45 days, a lien will be filed. So that's the first 45-day letter. If the owner doesn't pay in full at the expiration of that 45 days, the statute requires a second 45-day letter to be sent before a foreclosure lawsuit is filed, okay? Once a foreclosure lawsuit is filed, it's like any other lawsuit. The owner has 20 days to answer that. There's lots of foreclosure defense attorneys out there, so who knows what will happen after that. But the main takeaway for this type of Condo 101 class is you already have in the statute 90-day time frame. Figure in a few days to mail, let's say 95 days. 95 days before a foreclosure lawsuit's even filed. So if you're not referring the owner to your attorney, by the way, before it gets to the attorney's office, you have to give at least one 30-day notice, right? So it's a 30-day from the association, then the first 45 from your attorney, then the second 45 from your attorney before the foreclosure lawsuit is filed. So there's a pretty good length of time already built into the statute. So I'm just bringing this up to kind of put that in your mind if you are experiencing any sort of assessment, collection problems, to perhaps review what your internal collection policy is, okay? Let's do one more item, and then we'll perhaps take a couple questions, and then we'll go on to topic 2. We get asked questions a lot. Meetings of the association. There are only really, when you break it down, 2 types. Meetings of the board, that's where the board is voting, or meetings of the owners, where the owners are voting. We'll do the owner meeting first. Sometimes the only owner meeting is the annual meeting once a year, and we'll go into the election process soon. But that's where obviously the owners vote to elect the board. But certainly there could be other special meetings of the owners. For instance, if you're doing that material alteration project that we talked about earlier and you need owner approval, that could be done at a meeting of the owners. Notice of those special owner meetings, you're going to follow what your documents say. If your documents are silent, at least 14-day notice must be sent. Okay. Obviously, at meetings of the owners, of course, have the ability to attend, to speak on the designated agenda items. So that's meetings of the owners. The more common meetings are meetings of the board, obviously. That's where the board votes, okay? And just like meetings of the owners, meetings of the board, owners do have the statutory right to attend. They have the statutory right to speak on designated agenda items. The board can certainly adopt reasonable rules on how long owners can speak or when during the meetings they can speak, but they do have that right to attend and speak. Notice of board meetings almost always is just posted 48 hours prior. There's some exceptions if the meeting of the board is to adopt a special assessment, which is just when your regular assessments aren't adequate to pay for something. You might need to adopt a special assessment. The special assessment meeting is mailed to all owners and posted 14 days prior. You can use email to notice owners, provided that you have the owner sign consent to use their email address as the official method to send them association items. Okay, so if you have their signed consent, you can use email as the notice method versus having to physically mail. Okay, so just be aware of if you're doing that, a special assessment, or if you're adopting rules regarding the use of the individual units, that also needs a 14-day notice mailed and posted. Certain board meetings can be closed to owners. There's 2 types. The first type is if the board meeting, you have your attorney there, either, on the phone or physically there, or, on Zoom, and you're chatting about, pending or proposed litigation matters. Obviously, that can be closed to owners to attend. The second item is personnel matters that can be closed to owners to attend. Perhaps the board is thinking about terminating an association employee. That meeting can be closed. We get asked a lot about what is a meeting in the first place. Okay, and this is where it's a little bit gray. We hope at some point there'll be a good Florida case out there to clarify this. But a board meeting is when a quorum of the board is present to conduct the business of the association. So let's just break that down. Quorum is just a fancy word. It means the minimum number of board members that must be there for the meeting to even happen. Virtually always, it's a majority of your board. So if you have a 5-person board, you need 3. If it's 7, you need 4. 9, you need 5. 3, you need 2. Okay, so you need a quorum. If you have a 7-person board and your quorum requirement is 4, that means that 3 members of the board can always meet about whatever they want, right? Now, they can't bind the association, right? They can't approve things because it's not done at a meeting when a quorum of the board is there, but they can certainly gather and chat about whatever they want. The issue becomes is when you have a quorum of the board discussing the business of the community. That should be done at an open meeting of the board. And we get asked a lot. I'm not going to be able to go through every fact pattern, but certainly if you have a 7-person board, so quorum is 4, you have 3 board members hanging out at the pool, enjoying their day. And a 4th board member strolls to the pool, says hello to the other 3, and they're standing around. And the 4th board member just mentions, that sprinkler looks broke. We should probably call the manager to fix that. My view, and perhaps not every attorney shares this view, but my view is it is quite a stretch to conclude that 4th board member walking over to the 3 at the pool, so you have a quorum, just mentioning the word condominium or mentioning a sprinkler, that's automatically on the face of it illegal, where they have to stop and notice a 48-hour board meeting. I find that to be a stretch. The basis for my feeling is there's language in 718 that says board members cannot vote via email. So the logical conclusion when you see that in the statute is what? That board members can communicate via email, right? You just can't vote. So board members can communicate via email. To me, it's logical that they could chat on the phone about association business, just can't vote on the phone. And if you can chat on the phone, you should be able to chat face to face. Certainly never making decisions behind closed doors, never, approving things. But I do think it's a stretch to say it's an automatic statutory infraction if that 4th board member just happens to be in the same physical space as the other 3. Now, what you don't want to do is to gather behind closed doors, then go to a board meeting and just rubber stamp what you chatted about behind closed doors. That absolutely could be a basis for a challenge, and you want to avoid that. We always advise, in an abundance of caution, it's always better to have thorough and meaningful discussions about any item at the duly noticed board meeting. All right, that being said, let me see if there's a couple questions I can address. So we got a couple questions about material alterations. Again, look to your documents first. You follow what your documents say. So I don't know what your governing documents may say about that. It's true, getting the owner vote. We got a question about owners not participating. Apathy is a huge problem. It takes lots of practical legwork to get out the vote, right? Certainly management can assist you with that. But if your documents, for instance, require 2/3 of all owners to approve a material alteration, you better make sure you receive that. We got a question about the necessary maintenance exception and what qualifies. Of course, that's a judgment call. If you're thinking about proceeding with a necessary maintenance project, you want to make sure you have licensed professionals confirming the unsatisfactory state of whatever it is you need to fix. So it's not just the board saying we think it needs to be fixed. You have a licensed and qualified professional who has gone out there, done that job. We had the same question about levying a special assessment for a necessary repair item. Again, in our view, if you have documentation that something has to be fixed, you certainly can raise the funds required to do that. Okay, let me take a couple more and we will move on. Again, there's really no such thing as an emergency board meeting that you can avoid posting proper notice for, unless the state of Florida is under a state of emergency as declared by the governor, okay? So lots of boards will say it's an emergency. Well, it doesn't quite work like that. You almost always need to post 48-hour notice. That's just regular 48 hours. You can include a Saturday and Sunday as well.
Just a quick reminder for everybody. I see a couple of you posting some course-related questions in the chat. The chat is only for technical issues or non-attorney related issues for myself. please use the Q&A for your actual questions regarding the course. All right, Andy, back to you. Thanks.
You got it. And we have a lot of questions that are very specific facts about a fact pattern in your community. Obviously, that's outside the scope of what I can even begin to deal with today. You would certainly, if you're an owner unhappy with perhaps something that your board did, or perhaps you're in the minority on your board, you're not happy with what a majority of the board is doing, you certainly would need to consult with your counsel. We had a question about emotional support pets. I'm going to punt on that. We give whole topics about dealing with emotional support animals and assistance animals and service animals. I'll take a brief moment just to certainly advise or certainly suggest owners to go to our website, kbrlegal.com. We have a lot of upcoming free, we all love that, education courses on a wide variety of topics that can get more in depth on these specific things. Okay. And all right. So I will do my best to get to as many on-topic questions. If I don't get to yours, don't take it personally, please. We do our very best. Next topic, the annual budget and reserves. Okay, and I want to do a little bit of a caveat. Talking about reserves, you may have heard, hopefully have heard by now, of the new Senate Bill 4D that was recently adopted, talking about mandatory reserve requirements. It's a little bit more in depth than we have time to today. We actually have a course tomorrow specifically on the new Senate Bill 4D. So I encourage you all to sign up for that. But I want to give the general status of the law as it stands today, more of a overview. Hopefully you all know an annual budget needs to be adopted each year. There's two sides. There's the operating expense side, and that is certainly your day-to-day items, what the amounts are for insurance, landscaping, accounting, management, your attorney, and it should be a good faith estimate of what those expenses will be for the upcoming year. And you obviously look at the last year annual budget to see if there should be changes, okay? And the owner's proportionate share of their assessments are based on what those operating expenses will be, okay? So the second part, and this is the part that sometimes creates confusion, is reserves, okay? Reserves, you want to think about rainy day funds, where the owners are contributing more money either per month or per quarter for rainy day items that will need to be replaced at some point in the future, okay? As it stands right now, your annual budget for 2023, the statute requires there to be 4 reserve items: roof replacement, pavement resurfacing, exterior paint, and the fourth one is a general catch-all. It's any other item of deferred maintenance that exceeds $10,000, okay? So the statute says you're supposed to fully fund those 4 reserve items. As of right now, in 2023 and 2024, the board, if it so chooses, can present the option to the owners to vote to waive or partially fund those statutory reserve items. We have some clients that the owners have voted for 20 years straight to waive funding of those reserves. If your owners vote to waive or to partially fund reserve items for that year, obviously your assessment contribution will be reduced, right? Because you're not including the full reserve amount. And if you don't vote to waive, or you don't vote to partially fund, or beginning in 2025, when right now the statute says you won't be allowed to vote to waive or to partially fund, the amount you need to contribute to fully fund those reserve items will be based on what the remaining useful life of that reserve item is. To put it in a, hopefully an easy fact pattern, if your roof, and you should be having a reserve study done if you haven't done so already, where you have a qualified professional come out, examine your reserve items and say how long each item has left. Let's say you have a reserve study, your roof has 10 remaining years left. And it's going to cost, for easy numbers, $100,000 at the end of those 10 years to replace your roof. Then to fully fund, you need to do what? Contribute $10,000 each year. $10,000 year 1, year 2, year 3, all the way to year 10. At year 10, you would then have the $100,000. You then have those fully funded reserves to replace your roof. Obviously, I spoke about that new Senate Bill 4D, that there's something called a structural integrity reserve study that adds like 10 new reserve items that an association will need to reserve for. And beginning January 1, 2025, the statute as it reads right now, you won't be able to waive or partially fund those structural integrity reserve items. Again, to go in depth in Senate Bill 4D is outside the time that we have today. I think our firm has given at least 10 or 20 courses on Senate Bill 4D. So again, I encourage you to go to our website, check them out, and we have one tomorrow as well. So I certainly encourage you, if you're on your board, to take some time. But I just wanted to talk about just briefly the annual budget and reserve process. The board meeting where the budget is adopted, that's one of those board meetings that must be mailed and posted 14 days prior. And a copy of the proposed annual budget needs to be included. All right. So that's topic 2. I'm going to just do topic 3 quick because that's a fast one. And then I'll take a look at the questions and we'll keep on humming right along. The next topic is the financial reporting requirements. Hopefully you all know every association is required to have an annual financial report prepared each year. Owners get a free copy each year, or at a minimum, they get notice that a free copy is available to them. And the level of financial reporting is based on what your annual revenues are. And it's right in your outline. Obviously, if you have lower annual revenues, you're only statutorily required to get a lower level of financial reporting. So if you have less than $150,000, you only need a report of cash receipts and expenditures. If you're between 150 and 300,000, you need compiled financial statements. If you're between 300 and 500, you need reviewed financial statements. And if you have $500,000 or more, you need an audit of your financial statements. Now, let's say your annual revenues are $320,000. Okay, so per statute, you need reviewed only. But let's say the board, it's a brand new board, say, look, we want a higher level. We've never had an audit done. We think it's time to get an audit done. We want to increase the level of financial reporting. The statute allows the board on its own to increase that level of financial reporting. On the flip side of that, the board does not have the authority on its own to reduce the level of financial reporting. If the board wanted to reduce the level, let's say you have $320,000, so you need by statute to do reviewed, you can only do a lower level like compiled financial statements if you get owner approval for that. A couple other quick just financial filing items I want to just touch base on. I mentioned that every condominium association, you're a not-for-profit corporation. You're organized as a not-for-profit corporation, and you have your articles of incorporation filed with the state of Florida Division of Corporation, which is www.sunbiz.org. and you need to file your annual report on SunBiz each year. You know, if you're late filing, you might have an inactive status. It's not the end of the world. The state's happy to take your late filing fee, but you want to make sure, certainly, that you're filing your annual report with the State of Florida Division of Corporations. That just identifies who the current board members are, what their officer roles are, and most importantly, it identifies who your registered agent is. And that's important. Your registered agent is where official legal notices are sent, lawsuits, demands, any legal notice that a third party wants to send you, it'll be sent to your registered agent. I can't tell you how many times there's a new board, they're not aware who their registered agent is. It might be their old law firm, it might be their old president, it might be their old management. And then a legal notice is sent to that registered agent. That registered agent may not be acting as quickly as they should if they're not intimately still involved with that community. We certainly think for all of our clients, we recommend that our firm is the registered agent. It doesn't have to be, but whoever you choose to be your registered agent, make sure that they are aware that if they receive something in their capacity as a registered agent, that qualifies as official notice being sent. And certainly with, you know, lawsuits, things are time sensitive, right? So you need to make sure that you're aware of that. Also, the DBPR, that's the state agency, the Department of Business and Professional Regulation. They have a division of Florida condominiums, right? They have a subset. That's the state agency that regulates condos, and each association is required to pay an annual fee to the DBPR. That's what funds their, you know, education programs that they give. It funds their arbitration. So you want to make sure you're aware of that. And the third financial filing I just want to make you guys and gals aware of is your annual income tax filing. Yes, you are a not-for-profit corporation. That does not mean that you won't ever have some income. Okay, now assessments aren't income, but you might have a common element laundry room, right? Where you get income that way. You might have signed a bulk cable agreement where the bulk cable provider gave you some sort of per unit fee. That could be considered income. Okay, so you want to make sure you get with your licensed financial professional to make sure that those types of funds that you received are properly categorized and that you get your annual income tax filing. With that said, let's take a look to see if there's Q&A. We got a question on the percentage of the owner votes that needs to happen, or what the quorum requirement is for meetings of the owners. Quorum is, again, just the minimum number. If it's an owners meeting, quorum is the minimum number of owners that have to be there, either in person, or if you use proxies, or if you're voting electronically. Your quorum is document specific, almost always. And if your documents are silent, it'll be a majority of all owners. You need to be there to establish quorum. The actual percentage of approvals you need will depend on what the issue being presented to the owners, and that's a document specific item. I'm going to get to election soon, so we're going to save that election question. We got questions about, you know, rather than doing a special assessment, should we maybe enter into a loan with a bank? That's certainly a funding option. That's a business decision of the board. One thing I will say, some governing documents do require owner approval to get a loan or a line of credit. And if your documents require owner approval for that loan or for that line of credit, you have to follow that. Okay, even if the loan money is for a necessary maintenance item, you got to make sure to actually get the loan itself that you follow what your governing documents say. Okay. We got a question about the collection foreclosure process. As I said, it's possible that an owner could lose his or her home. And sometimes if the association is if the association wins the foreclosure, right, they get a default judgment or they get a satisfactory judgment, it will go to foreclosure sale. Let's say the owner owed the association $30,000. The association gets a judgment for $30,000. It goes to foreclosure sale. The association will bid its judgment amount. It'll bid that $30,000. And if there's no other parties out there that bid, it is possible that the association actually becomes the record owner of that unit through the foreclosure process. Certainly, you're going to want to get with your attorney dealing with that. Okay, I'll save that election question. Going on to topic 4, the official record keeping process. Hopefully you all are somewhat familiar with this. This is a statutory item. It's right in 718, where every association is required to maintain official records of the association. The list is right in the statute. It's right in your outline. It's mostly common sense things. It's the copies of your governing documents, it's contracts, it's voting items, it's insurance policies. Okay, it's any other written record that relates to the operation of the association. That's part of the official records that you must keep. The rule of thumb is you should keep everything for at least 7 years, except for, there's always exceptions, except for voting materials. Those are kept for 1 year. Competitive bids that you might get, those are only kept for 1 year. And your governing documents and the minutes of your meetings, those need to be kept permanently, okay? But that's all right in the statute. You want to make sure that you're aware that owners have the right to access and inspect them, and they can make copies of those official records. If you get a written request by an owner to have access, you want to make sure that you're providing at least one appointment time within 10 business days. So you don't count Saturday or Sunday. You want to make sure that, again, 10 working days is, I think, the word that the statute uses. And we get asked a lot, can you just email the records to the owner? Sure, if it's easier for you or easier for your manager. If someone's just asking for, the latest insurance policy, you don't have to make them come in to inspect it. Sometimes it's a lot easier just to email to them, and that's fine. Just make sure you do it within that 10 working day time frame. Also, certain items are part of the official records that must be maintained by the association, but they're private. Okay, they should not be provided to the owners, and this is based on what the statute says. Those are such things as attorney-client work product, personnel files of association or management company employees, with the exception of the management contract. That's not private. Owners do get to see that. Any hospital information you have of owners, and also what I call, personal identifying information of owners, social security numbers, driver's license, bank account, that type of stuff. That's all private. Owners don't get to see it. What I will say is the account ledgers of the owners showing if they paid on time, that's not private. Okay, I think there's a misconception out there. If an owner wants to see who's paid on time or not, they do have the ability to see that. What you don't want to do as a board, and you may think this is somewhat outlandish, but I've seen it happen multiple times, you do not want to be posting who hasn't paid in the common elements. That I've seen that happen, and that's a big no-no. And the main reason is, let's say the board is frustrated with the same 5 owners that always pay late, and they want to post their names on the common element board that they haven't paid. Let's say you post it at 1:30 that John Smith hasn't paid. He owes $3,000. John Smith pays in full at 1:35. At 1:40, that posting is still up. That's bad, right? You essentially have distributed and taken proactive activity to publish a false statement on someone's ability to pay their debt. So that's not good. That's different than making the account ledgers open for inspection if an owner requests it. And that certainly is something that the association is required to do. Also, condominiums that have 150 units or more, you need a website that owners have access to. It needs to be a password protected website. But if you're 150 or more units, you need a website, and the statute outlines the official records that must be posted and available to owners on that site. It might be annoying to get it up and running because you got to upload and get everything there, but it will save you time going forward because it certainly helps with record inspection requests. Because if it's on the website, certainly you can reasonably direct owners there. Okay. All right. That's the official record portion. Let me see if there's any relevant questions on that. All right. We have a very specific question on the reserve items. Certainly, insurance premium cost is a whole other topic. I know most communities, if not all, are being hit with a significant insurance premium. The question is, can we use reserve funds for that? Reserve funds by statute are restricted. Okay, they can only be used for those reserve funds unless you get a vote of the owners to use those reserve funds for an alternate use. So in my opinion, that board who's considering using reserve funds for something other than that reserve item, make sure you get with your attorney, and it's likely that to best protect you all, you should get that owner vote first. Certainly owners might be in favor of it so they don't have a large special assessment. Okay, we had a specific question on the management company's role. Certainly that's per their contractual agreement, and the fees that they're paid will just depend on what their management contract says. With all contracts, and I'll touch on this a bit later, and I'm certainly not suggesting for every $200 sprinkler head repair, but if you're about to sign any sort of service contract or any contract that's for any length of time or any significant amount of money, it's probably a good idea to have your attorney review it first. Vendors, I love them. We're a vendor as well. But sometimes the vendor contract is drafted to protect who? The vendor, right? And that could be for any vendor, landscape vendor, roof contractor. So it might be a good idea to have your attorney review that vendor contract to perhaps add provisions that better protect the association in a manner that's still fair to the vendor. And I think that's a good rule of thumb. We got a question about operations, and I'll get to contracts a bit, about how many board members must sign a contract. There is no legal requirement. The only requirement is that a majority of the board must approve that agreement. If a majority of the board approves that agreement, and there should be minutes of a board meeting reflecting that, then whoever's authorized to sign, usually it's the president, doesn't have to be, but whoever's been approved by a majority of the board to sign, that's who can sign that agreement. We got another question about, are all board members given access to contracts and financial reports? Well, certainly that's part of the official record. So whether you're on the board or not, you're likely an owner, and you certainly have the ability to see that. What happens from time to time, and you might be shocked, but sometimes boards don't get along, and there might be, let's say you have a 5-person board, 3 get along, 2 do not. For whatever reason, the 2 make repeated demands upon the management company or the other board members. They want immediate access to all sorts of things. At the end of the day, it's a majority of the board who can decide which board members have unfettered and unlimited access to these things. As an owner, those 2 board members absolutely have the right to make a request to see it, but they don't have some special immediate right just because you're on the board. We got a general question about the transition of old board members to new board members. That's something, a lot of practical things you want to, management can certainly help with that. I think new board members should attend a course like this, but certainly, hopefully it's a smooth transition where they are familiar with whatever pending projects there are, and as much, certainly as much time that the old board members can spend with the new board members, I think everyone will be better off. All right, great. We are getting to elections, and I left one question up that is pertaining to elections. It's likely that you perhaps recently had your election. There's really not an election season per se, but it's usually, you know, September, October through March, I would say, is most common. But elections in condos are one of the most heavily regulated areas per statute. Okay. So, excuse me one second. So the process, it's in your outline, but it's a 2-notice process. Okay. The first notice, and by the way, the election happens at the annual meeting of the owners, right? Because the owners are voting. So the first notice must be mailed to all owners and posted 60 days prior, not 59 days prior, not 58 days prior, at least 60 days prior. Okay. The second notice of the annual meeting election must be mailed and posted between 14 and 34 days prior. So not 13 days prior and not 35 days prior, but between 14 and 34 days prior. So those 2 notices must be sent. Now, the way it works is any individual, including a current board member, if his or her term is expiring, if they want to run for the board again, they must submit their notice of intent to run 40 days prior, not 39 days prior, but at least 40 days prior. For those candidates who timely submit their notice of intent to run 40 days prior, they have the option, it's not required, but they have the option, if they want their 1-page candidate information sheet, their resume, if they want that included with the second notice, that candidate information sheet must be submitted 35 days prior. Okay. So the way it works is, first notice goes out at least 2 months prior. Let's say you're a 5-person board. You get 7 candidates that timely submit their notice of intent to run 40 days prior. Let's say all 7 timely submit their candidate information sheet 35 days prior. So now the second notice, which must be sent between 14 and 34 days, the second notice includes a ballot, which lists those 7 candidates in alphabetical order by last name. There shouldn't be any little stars by the current board members' names or anything like that. Just list the 7 candidates by last name, alphabetical order. So that ballot's included with the second notice. Their candidate information sheets are included with the second notice, and the inner and outer envelopes are included with the second notice. And the way it works is that gets mailed to all owners. I'm an owner. I get the second notice package. I open it up. I see the ballot. I can vote for up to 5, right? It's a 5-person board. I see the 7 candidate names. I can vote for 5. I can vote for 4, 3, 2, or 1. Just can't vote for more than 5. I check off the names I want. I put the ballot in the inner unmarked envelope. It usually says something like ballot envelope. Seal that up. I then, as the owner, take the sealed ballot envelope, put it in the exterior outer envelope, seal that outer envelope. And then on the exterior of the outer envelope, there's a place for me to sign and put my unit number. I have to sign that outer envelope. If it's not signed, it's an invalid. It'll be marked disregarded. Okay. There is no proxy voting for the election. Okay. So you as an owner, you're the one that fills out your ballot. You're the one that has to sign the exterior of that outer envelope. Now, if that process is done, I have my sealed, outer envelope with the inner and the ballot inside, and I'm 94 years old. I don't feel like walking down to dropping it off. Of course, I can have a neighbor bring my completed sealed, signed envelope to the election. That's totally okay. That's not proxy voting. Proxy is where you're assigning the ability for someone else to vote for you. At the meeting itself, you need to have a current owner roster. You need to have extra ballots and envelopes there. If someone hasn't voted, they need to be provided the opportunity there. And the way it works is you should be verifying the envelopes with the roster to make sure each unit only votes one time. So before you open up anything, you look at the exterior. Okay, John Smith, unit 101. You go to the roster, you check off that John Smith voted. If you're a larger community, I think anything larger than like 80 units or so, even less, the law allows you to do that verification process where you're not opening up anything. You're simply just checking off on the roster that that unit voted. It allows you to do it before the election happens. You just need to post a notice 48 hours prior where you have your independent election committee do that task. So if you have your annual meeting at 5 o'clock, you can have your verification meeting at 3, where you could verify all of your envelopes. That'll save you a lot of time. Also, the law allows electronic voting. Talk about saving time. Electronic voting does not mean you just send a Gmail and you write back on your AOL or your Gmail, I want to vote for these 5. You need to have a third party. There's lots of electronic voting software companies out there where they have a secure website that each owner logs into and they can submit their vote electronically. That certainly makes things go a lot faster. At the election, you just press a button and those electronic votes pop up. The caveat to that is you do need to get the owner's prior consent for them to use electronic voting. You can't force them to. So if you have owners that don't agree, then they have to be allowed to vote the old-fashioned way. But certainly, electronic voting can be a huge help. There does need to be a board meeting notice 14 days prior. That's another exception where the board approves implementing electronic voting, and then you need to get the owner's consent to use it. But if you have 200 units and you have 150 that agree to electronically vote, it'll save you a lot of time there. All right, a couple other election matters. All of the election materials, even the inner envelopes that look like trash, you keep everything for 1 year. So the unit owner roster, the tally sheet, the ballots, all of that kept for at least 1 year, and owners have the ability to inspect that. Regarding eligibility to serve on the board, there's a misunderstanding out there where the statute actually does not require board members to be owners. You might be thinking, that's crazy. Who would want to be on the board if they're not an owner? I can share with you, we have multiple clients where there's been someone who's rented a unit from the same owner for 25 years, and she's just as invested in the health of her community as an investment owner that's been there for 1. Okay, now, lots of governing documents. Again, this is document specific, so I won't know unless I reviewed your governing documents. Lots of governing documents require board members to be owners. And obviously, where documents require that, then you have to be. I would venture to say the majority of documents do, but not all of them. So if you're not sure, that's something you should have your attorney look into. A couple other eligibility requirements. If a candidate is delinquent to the association on that 40th date when the notice of intent has to be turned in, if they're delinquent, they owe the association money, they're not eligible to run for the board. You want to make sure that your accounting records are current, but if that's the case, they shouldn't be included on the ballot. You should send a notice to that person saying, we got your notice to be a candidate. The association records reflect that you're past due. Therefore, per statute, you're not eligible to run. Excuse me. Also, once a board member is elected, they're already on the board. If a board member falls behind more than 90 days, they're not more than 90 days past due, they're automatically off the board. It's not a board vote. It's not like the board has to approve it. It's an automatic. They're off. and it creates a vacant seat on the board. So make sure the goal is obviously they want current board members not to become more than 90 days past due. Regarding the term of service, unless your bylaws say something else or your articles of incorporation say something else, board members serve a 1-year term. Sometimes the bylaws or the articles of incorporation will say board members serve 2-year terms, or they may even serve staggered terms where you have, 3, let's say you have a 5-person board, you have 3 elected 1 year, 2 elected the other year. So just check your bylaws and articles. If you're not sure, if they're silent, board members serve 1-year term. Regarding serving for a long period of time, the law was changed in 2018 to say board members cannot serve more than 8 consecutive years. It's effective as of July 1, 2018, so you don't have to worry about it until July 1, 2026. But if you have a board member and who's a glutton for all sorts of things and they're serving on the board for 8 years straight, beginning 2026, they might be termed out with some important exceptions. The exceptions is if there's not enough candidates for an election, that board member can stay on, obviously. The other exception is if that board member gets 2/3 of the owners vote for him or her, they get to stay on as well. And if you think about it, I think that makes sense. Why throw someone off the board just because it's their 9th year if 2/3 of the owners voting want him or her to stay on? So the owners elect the board members, right? Once the election's done, usually it's right after, but it doesn't have to be unless your documents require it. But usually there's a board meeting to organize the officers, right? And the officers are the president, vice president, treasurer, etc. Those officers are appointed by the board members themselves, and they serve at the pleasure of the board. So it's a majority of the elected board who votes for president, vice president, treasurer, etc. And those officer roles, they can be reorganized anytime at a duly noticed meeting of the board. So for some reason, a majority of the board votes to appoint John Doe as treasurer. 4 months later, majority of the board's not happy with John Doe as treasurer. You can post a board meeting 48 hours, reorganization of officers as an agenda item, and you can vote to replace John Doe as the treasurer with the new treasurer. Now, what the board cannot do amongst themselves is they can't throw someone off the board entirely, right? You can't remove someone completely from service just by a board vote. The only way a board member is completely, voted or thrown out of service is if they're more than 90 days past due, or if there's an election, obviously their term expires and they either don't run again or they're not re-elected, or if there's something called the recall process, right? Recall just means that requires a majority of all owners to vote to recall and remove one or more members from the board. Recall can be done without cause. You don't need to prove that a board member did anything wrong. It just requires a majority of the owners to agree. There are some statutory sort of quirks on how the recall process works. So if you're a concerned owner group and you're thinking about recalling the whole board, you might want to get with an attorney to make sure it's done right. In the same fashion, if you're a current board member, let's say a majority of the board wants to challenge a recall attempt, that majority of the board should certainly contact the association attorney just to make sure that the recall is done right. But again, the main takeaways in this type of general education course is that recall must be done by majority of the owners, and it can be done without cause. The certification requirement I talked about when I first started, that the statute requires board members to be certified. There's really no really meat in the law if you don't get certified. The goal is to what? It's to encourage education, right? So you're supposed to be certified within 90 days after being elected or appointed to the board. If it's your 91st day, don't worry. What the statute says is that you are temporarily suspended from service, but you're immediately and automatically put right back on once you get certified. And even if you voted on an item when you weren't certified, not being certified doesn't affect the that action being valid. Okay. Again, you can be certified one of two ways: taking a state approved course, just like the one you're in, or there's a very simple sort of, I call it like the Scouts honor statement, that you say you read the governing documents and you agree to uphold them. An important thing, sometimes if you're in a hotly contested election, I'm sure Trident has never seen those before, but they do come from time to time, where, you know, owners or candidates that lost maybe, they allege all sorts of things. You did it illegally or whatever the case may be. An election dispute must be filed within 60 days of when the election happened. So if you're on a board now and it was a hotly contested battle and it's the 61st day, you can open up your bottle of champagne. There won't be any election challenge being made. The reason why that law was changed is people were waiting too long to file an election challenge. And by the time it got heard, the next annual meeting was almost there. So it wasted a bunch of money and funds. If there's a vacant seat on the board during the term, let's say you have a 5-person board, one of the board members resigns, you know, they just don't want to serve, you know, obviously it's up to them, or God forbid they pass away, or they're more than 90 days late and they're automatically off, but there's a vacant seat on the board. Unless your governing documents say something else, which is somewhat rare, the remaining board members are authorized to vote to appoint someone to fill that 5th seat, and that replacement director will serve the unexpired portion of that term. All right, so let me see if there's any election questions on point. Oh, I saved this question. We got a question of, I should say, you obviously don't need an election. Let's say you have a 5-person board, but you only get 5 candidates who want to run, or 4, or 3, or 2, or 1. Obviously, there's no election. You don't have enough candidates. What will happen, and you don't mail out ballots, obviously, you still mail out the second notice. But what the second notice will say is the association did not receive enough candidates for an election. So at the annual meeting, those candidates will just simply be seated as the new board. Let's say it's a 5-person board. Let's say you only get 1 person. That 1 person is sat as the board. Then at a future board meeting that's noticed 48 hours prior, that 1 board member can appoint board member 2. Those 2 appoint 3. Those 3 appoint the 4th. Those 4 appoint the 5th. We got asked a question, which I saved, is what does a board do when no one wants to serve? Not one single person. I always say, I find that hard to believe that there's not one. It's possible, but I would suggest canvassing very aggressively, respectfully, but finding at least 1 person to step up. Because what you don't want to happen, if no one truly will serve at all, is any owner can basically file a appointment with the court to get a receiver appointed, which you don't want to do, because a receiver basically gets paid out of your assessments, out of the association funds, to serve as the board. So that is worst case. That's the last case. So if you even are thinking that might be a problem, get with your association attorney, find someone who's willing to step up, because you only need, certainly, you know, you only need a quorum to function, right? So if you have a 5-person board, you only need at least 3. You just need to get 3. We got asked a question, very fact specific. If you find out during the election, you find out a candidate wasn't eligible to run, well, that's that this isn't a legal term, but that's a cluster, right? You guys, you know, that's not good. Hopefully you get with your attorney. At the end of the day, if it's truly went haywire and someone was included and they shouldn't have been, and no one realized it until the election, get with your attorney. But sometimes the most reasonable and fair approach is just to start the process over again and make sure that you only have eligible candidates there. All right, we got a question about mailing of the election materials. Obviously, the board and management doesn't have control over the US mail. They just don't. You have to mail the notice between 14 and 34 days. It is true that there could be owners that live outside the United States or outside of Florida that don't get it in time. Unfortunately, that's not like the association's responsibility, right? You know, certainly if they get it late and they're worried about mailing it back in time, those owners can send it certified mail. You know, you do the best that you can do, but it's not a requirement of the association to confirm that 100% of the owners receive the election package, or else oftentimes there would not be any election. Okay. One way to perhaps combat that is to certainly maybe have electronic voting. That could be helpful. Okay, we got a question. Let's see if there's any election issues here. All right. We got asked a lot. Sometimes, let's say an owner who wants to be a candidate for the board is involved in a lawsuit with the association. Can they run and serve on the board? You might be surprised, but the answer is they can. That's not a statutory factor that automatically excludes that board member. Now, obviously, when the board is meeting to discuss that lawsuit, that board member must be excluded from that portion of that meeting. And that board member who's involved in that lawsuit is not privy to any of the information regarding that. And that certainly needs to be clarified and straightened out with that board member. Okay. Again, I had a similar question. What if someone wants to run for the board and they break the rules all of the time? Again, that in and of itself is not one of the statutory items that disqualify someone from running for the board. We got asked, can a member of the board bring a lawsuit against the other board members? We live in a wonderful country. Anyone can sue anyone for any reason at any time, whether it has merit or not. Of course, that's a whole different question. All right. The annual meeting notices do not need to be sent via certified mail. We got asked a question about that. I'm trying to stay on topic. We got asked a question about Kaufman language. This is a pretty in-depth topic, but briefly, Kaufman language is named after a court case where it talks about whether changes to the Florida statutes automatically apply to your community or not. And if your governing documents have what's called Kaufman language, which basically says that your community is governed by Chapter 718 of the Florida statutes as amended from time to time, okay? That as amended from time to time, that's what Kaufman language is. And if you have that Kaufman language, that means you never have to worry about whether new changes to the statute will apply to your community or not. They will automatically be incorporated. If you do not have Kaufman language, then it's a much more detailed analysis whether new changes to the law will apply. It'll matter whether the statutory change is substantive or procedural, way outside the scope of what we're going over today, but I just thought I would give a quick answer on that. Just give me 1 second here, and we'll get to the last couple of topics, and then we'll take some questions, and we'll be good. Give me 1 second here. Okay. I got a very specific question about there's a sub association with a master. How did the elections work? I mean, that's very document specific. Unfortunately, I'm outside of the what we're chatting about today. All right, we've got about 15 minutes left. We're cruising along. We've hit all 5, so you are officially board certified, but I do want to just touch base on the last 2. The second to last topic is the dispute resolution. This is when your legal counsel gets involved. That's when an owner has violated the rules. You've attempted every way to solve it. You've amicable request, violation letters, demand letters. That commercial truck is still there. You find them. You've done all sorts of things. The truck is still there. How do we get rid of that truck? That's when you get your attorney involved. And under 718, there's a detailed procedure before a lawsuit can be filed. The law was recently changed where there's a pre-suit mediation process that our firm prefers to go to versus arbitration. That's where you try to have an independent third party mediate it. And if you get a resolution that's agreeable to both parties, wonderful. If that mediation fails and an impasse is reached, then the association can actually file a lawsuit in state court against that owner to seek what's called injunctive relief, get a court order forcing that owner to get rid of that truck. And oftentimes, if the association is the prevailing party, they win, they can seek to recover their attorney's fees and costs directly from that owner. So I think it's a good idea just to be familiar with the dispute resolution. This is the formal dispute resolution process, right? This is when all other attempts have failed. There's going to be obstinate owners out there. It's just the nature of the work that we are in. The last topic, and then I'll take questions on that and any other questions you have, is the contracts and competitive bid process, how that works. I don't want to get on my soapbox too much here, but I want to make sure that board members are aware. If you're not fully clear on what I call the who, what, where, why, when, how of how a vendor is going to do something pursuant to a contract, do not sign it, right? There are very smooth talking, charming salespeople out there that you just trust them and they just are great. I have lots of family members that are in purely sales. I love them too, but they are charming. And sometimes salespeople promise all sorts of things. And at the end of the day, a judge will only look at what's called the 4 corners of the contract. What does the contract say? So if the salesperson or the vendor is verbally promising you something, then in my mind, they should have no problem putting it in the contract, right? There shouldn't be much argument about that. So if you were promised something and you don't see it in the contract, don't sign it until you get adequate clarification on why it's not there. And then you can use your business judgment whether you want to go forward with it or not. Okay. We suggest that all contracts should be in writing, obviously. And again, you should know what the who, what, where, why, when are. We think your attorney should review contracts of any length of time or any significant dollar amount. Oftentimes for service contracts, whether it's a landscape vendor, a maintenance company, a pool cleaning company, even management contracts, we do think it is a good idea for the association, not always, but it's usually a good idea that you have the ability to terminate what's called without cause by providing a certain amount of notice to that vendor, whether it's 30 days, 60 days, 90 days, even if you don't have the right to exercise that without cause termination for maybe 6 months during the initial term. But at some point during that term, we do think it's a good idea to be able to terminate without cause. I can't tell you how many landscape contracts I see that are 3 years, no ability to terminate unless you prove a breach and you give, let's say, notice and an opportunity to cure to that vendor that this is what you're doing wrong, you must cure it. I have yet to met a landscape vendor or a pool cleaning vendor or any vendor that will stand up and say, you know what, hand up, we breached, we can't cure, you're free to go. It just doesn't happen. You know, they will always have their side of the story, and arguing about whether someone breached their duty or not, that can be very costly if you have your attorney involved, and very time consuming. So I suggest to, you know, why not have just without cause? It can be because the wind blows a certain way, right? The board, I can't imagine they would ever be unhappy with our firm, but if they are, they can turn, you know, they can go their own way, right? That's just the way I think a lot of service contracts should be. So I just wanted to point that out. Regarding the competitive bid process, there is some misunderstandings about that. What the Florida statutes say, okay, what chapter 718 of the Florida statutes say is that you're required, an association is required to get competitive bids if the cost is more than 5% of what your annual budget is, including reserves. So if it's more than 5%, you have to get competitive bids. Competitive legally only means at least 2. Now, of course, good rule of thumb, good business practice, you know, you want to try to get at least 3, right? See if one's too high or too low, but competitive legally only means 2. So if it's above that 5%, make sure you get competitive bids. Of course, the law loves exceptions, and there are exceptions with the competitive bid process, even if the cost will exceed that 5% amount. Contracts with your property manager, your accountant, your attorney, your engineer, your landscape architect, those are not subject to competitive bids. Now, that doesn't mean the board can't get competitive bids, okay? You're just not legally required to. Bids must be kept for 1 year in the official records, and owners certainly have access to it. Okay, with that being said, let me take some last questions. We got a question about what notices are required to be sent certified mail. Really, there's very few. You can always choose to send them certified mail, but the only certified mail letters that you have to send deal with when your attorney gets involved, sending collection letters, like notice of intent to lien, all of that stuff. Notice of meetings for the association, notices of meetings for the board. If it's a 14-day notice that you have to mail, you never have to send it certified mail. We had a question about can the management company stop the president from acting on his own? All this stuff. Management company, I'm not going to speak for, you know, our very well versed and respected managers here. They're not superheroes. We're not either, right? At the end of the day, they're authorized agents of the board. And to me, if you have a rogue member of the board, regardless of whether it's the president or not, it's incumbent upon the majority of the board, because remember, you can reorganize officers. So if a majority of the board isn't happy with what the president is doing, it may be time to hold a board meeting to reorganize, remove him as the president, get someone else in who isn't taking rogue actions. Okay, we got to ask the question, can board members be appointed to committees? Unless your documents restrict it, committee members, there could be all sorts of, you know, landscape committee, social committee. If you want to levy a fine per statute, you actually need to have an independent fining committee established. That's the only committee, the fining committee, sometimes it's called a grievance. That's the only committee per statute that board members cannot be on, okay? That fining or grievance committee needs to be independent. But other committees that the board just creates, unless your documents say something else, that board members can certainly serve on that. Okay. We got a question about what's a board meeting or not. Again, this is the famous question. You have a quorum of the board hanging out at a bar. Perhaps something comes up about the association. Perhaps lots of things comes up about the association. Is that against the statute or not? Ultimately, only a judge can make the final ruling, okay? I submit to most board members, you know deep down if you're meeting behind closed doors and taking action on behalf of the board, if you are. We encourage against that, okay? There's certainly gonna be times where you're purely just exchanging information that perhaps that does not cross over the line of a meeting that needs to be noticed in advance. We always suggest it's better to err on the side of caution and just avoid that. Question about the official records that you have to keep permanently, the minutes of meetings, keep them permanently. And your governing documents, obviously, there should be no reason to get rid of those, but keep those permanently. Okay. With that being said, I believe the last question, I believe he's on the board, is my fiduciary duty to the members or the corporation? That's an interesting question. Ultimately, the corporation is made up of who? The members. There are no other people that are members of the corporation but the members. So to me, the primary goal is you have a fiduciary duty to the members, who are almost always defined as the unit owners. With that being said, 156, pretty good, Jeff. I didn't hit the nail on the head right at 2, but
Did fantastically. Just one comment. How the heck is a board supposed to research stuff to bring to the owners if getting all together is, by some, is considered a meeting? That has never made any sense to me, because you want to gather all of the information, do all of the research, get everything you need so that the materials you bring to the folks who live there is accurate information that all the board members understand. Are all the board members supposed to meet 2 at a time here and there? I mean, it doesn't make sense to me.
Yeah, no, and you're not wrong at all from a practical sense. And personally, I tend to share that view. I think it's a very strict reading of the statute. I'm aware of other respected practitioners in the field. They take a very, what I consider a narrow view of that.
Yeah.
You can line up 100 attorneys. You might get 51 and 49 saying it. The goal is hopefully there'll either be legislative clarification, which there was a little bit saying board members can't vote via email, which at least obviously you can email each other. But until there's really good case law or some legislative fix, I have owners and board members and attorneys, they argue about this until the cows come home. And it's just one of those things. But I certainly tend to agree. There has to be some level of common sense involved where, just because that 4th board member says, hey, look, I think this is a good landscaper, his rate is this, and he mentions that, and there's a quorum there. I mean, to me, that seems sort of foolish to say that they're unable to ever chat like that.
Yeah. And I had a picture of you on a soapbox, but I wasn't quick enough to get it on.
We'll do it for the next time.
Much, and thank you, Andrew, for running us through that stuff today. It was great information. I always love to hear. I think I've sat through 10 of these in the last couple of years. I still always pick up something new. So good to sit here and enjoy. And glad so many owners and board members came to join us